Okay, this afternoon, I would try to go through this as quickly as possible, as I understand that there is a time factor. I want to look at restorative justice. And right, in presenting this presentation here, I would just have an introduction. We could look at restorative justice. There are different approaches. The particular one that I would want to look at is restorative justice conferences. So we look at the definition for that. We look at the objectives. We look at some conferences, some experiments on reparation and results. Now, the term restorative justice, we use this term broadly, really, to describe a number of programs geared towards correcting the harm done to a victim by an offender in a very perhaps unstructured manner. In Trinidad and Tobago, we have what we call victim-offender mediation. We have a mediation act, Act number 8 of 2004, and that act is very detailed as to how a process will take place under mediation. And I can tell you, we have a mediation board here. It is very well practiced in Trinidad and Tobago. However, and it falls within the context of restorative justice because you're trying to restore the victim in the original capacity that victim was before he or she was affected by the crime. But I want to look at a process called restorative justice conferences. And there are three main groups here. You have family group conferences. And this first came about in New Zealand, where families got together with juveniles. Whenever one of them committed an offense, both families would come together, look at the harm done to the victim, and come up with solutions as families. And then you have a diversionary conference. And this is the name that was used in Australia to describe a number of experiments, again used with juveniles, as a diversion from going to court. It is an alternative to prosecution. So let's just look at two definitions in the context of restorative justice conferences. And you will note that at the end of the definitions, the names of certain individuals who would have coined these terms, and they would have done extensive work in these areas. And we have here, restorative justice is a process whereby parties with a stake in a specific offense collectively. And when we talk about parties here, we're not just talking about the victim and offender. We are talking about other persons who would have been affected by the crime. Because for restorative justice, a crime is not only perpetrated against the victim. Other persons who might be affected might be the family members of that victim. For example, in the context, a victim might get mugged, unable to go to work, or is hospitalized. How the income from that family member is being addressed, where it is impacting on the lives of other family members. So when you have a conference like this, you also include family members. So you will find out from the victim who else they would want at that conference, and likewise, the same for the offender. But we'll understand as we go along that for a conference even to take place, the offender must accept responsibility for the offense. The other definition speaks to a planned and scheduled face-to-face conference in which a trained facilitator, and in a lot of these experiments that was done out in England, New Zealand, and the UK, as well as the US, a lot of the trained facilitators were police officers. So they bring together offenders, their victims, and their kin and communities in order to decide what the offender should do to repair the harm that a crime has caused. So restorative justice is now a global phenomenon operating in several countries. And we identify some of the countries here. We have Sweden, Singapore, Australia, New Zealand, parts of the UK, parts of the US. And its claim is that restorative justice is seen by victims and offenders as a more humane and respectful way to process crimes than conventional justice processes. Now, how is it used? It is used at post-arrest, diversion from, and a substitute for prosecution in court. And we will see from just a few of the experiments using juveniles, where instead of taking the juvenile to court, they went through this process of restorative justice. In some cases, in some jurisdiction, after a guilty plea is made in court, but before the person is sentenced by the magistrate or judge, they go through a restorative justice conference. It can also be used as part of a non-custodial sentence, if requested by probation officers, and after a period of imprisonment prior to release. And a lot of these conferences do take place in prison, where you get the victim going to the prison to meet with the offender just before he or she is released. But again, the offender must agree to that, and even the victim too. It is if the victim really wants to go through that. And we stated this before, the offender must accept responsibility for the crime. The conference is being conducted by trained facilitators. It is held in police stations, in prisons, community centers, and other appropriate places. Now, what is the effectiveness claim of restorative justice as opposed to the criminal justice system? Firstly, it is an attempt to repair the harm a crime has caused rather than inflicting harm on an offender. Studies have shown that persons who have gone through this process, there is less repeat offending. More repair of harm to victims. Very often, victims want to say, some of them prefer to meet with this offender face on face to really find out why. Why am I a victim? Why did you choose me? And also to let the offender know the kind of impact that particular offense had on their lives. Fewer crimes of vengeance by victims. And someone was stating to me, in our case where we have a lot of reprisal for a number of offenses committed against persons. More reconciliation and social bonding among families and friends affected by crime, and more offenses brought to justice. And then you have reintegration of the offender. Now, how does that work? This whole process of restorative justice conferences has its theoretical basis in a couple of theories. And the first one we have here is reintegrative shaming by John Braffett, What Buffett saw is that when persons went to court, they left with a label. They were stigmatized. The entire community was aware of this person's offense, and the person may have been convicted or so. And that label remains with the individual. Buffett is saying, if such a person gets an opportunity to go through a conference, the idea is to bring to that person consciousness, the level of harm done to the victim. And you found that even though the person, whilst they're ashamed in the open court, even though they are ashamed going through with this process, it is less stigmatizing for the individual, because the individual gets an opportunity very often, possibly, to be remorseful. And then you have procedural justice being done by Tom Tyler. Tyler assessed a number of individuals and realized that persons do look at how they are being treated in the criminal justice system. And even though they might be guilty of the offense, the fact of the matter is, if they perceive that they are being treated fairly, they will cooperate much more. And he would have done a lot of research in this area. And then you had the theory of defiance done by Professor Lawrence Sherman, who I think most persons will see him tomorrow. Professor Sherman has stated that coming out of labeling and stigmatization, some people reach the point, well, I don't care. That is how they see me, and that is how I will be. And so you find there is a little hope in such rehabilitation for a person like that. So they feel that they are unfairly treated, may or may not be, so they continue to defy the law. So that's the basis for the theory of defiance. I just want to highlight just a couple of the experiments being done across the world. And this particular one was done in Australia by Professor Heather Strang, also a university lecturer out in Cambridge. And it became to be known as the reintegrated shaming experiments. It involved juveniles 18 years and under, and young persons 30 years and under. What was the goal of this particular experiment? It was to replace the usual focus of the judicial system in an adversarial setting, that is like the offender against the state, and to replace it to focus on repairing the harm experienced by the victim and by the community, participation and reconciliation between victim, offenders, and members of the community or persons who have a stake in the process. The criteria used, you had property crime involving offenders who must have been under 18 years of age. Violent crime by offenders, at least one under the age of 30 years. Okay. Offenders and co-offenders had to make full admissions about the crime. That's the only way you can have a conference. The offenders must accept responsibility. And it's a voluntary process, of course. The offenders in these matters had to have no outstanding warrants or bonds. This took the form of random assignment, and you had the involvement of a team as matters came to various police stations which were involved in the entire process. this team would randomly, using a process, a scientific process, randomly assign some cases to go through RJ and some to go to the court. With the youth property crime, and this is the figures you had, because what we must bear in mind that none of these went as how it should have been done. Some conferences were not held because offenders failed to cooperate. Some were not held because offenders failed to appear in court. And in some cases, the facilitators failed to organize a conference. But those that were treated, under the property crime, you had 83 out of 22 persons, which was 68%, that went through conferencing, and 105 out of 127, 83%, which were assigned to court. With the youth violence experiment, 49 out of 62 persons, 79%, went through conferencing, and 54 out of 59, 92%, went to court. And these are some of the results after the conferencing, after the matter was heard in court. Both groups were surveyed, they were interviewed, and these are some of the outcomes. Some of those who went to court, being asked the question, do you anticipate that the offender will repeat the offense on you? And 18% expected to be re-victimized. In case of those who went through an RJ, only 5% said they felt that they could be re-victimized. This question was asked solely to conference victims. Are you afraid of the offender? And this was asked before and after. And before the conference, 20% stated they were afraid. After the conference, you had only 9% saying they were afraid. Were you satisfied with the way your case was dealt with by the justice system? Only 46% who went to court said they were satisfied. Those who went to the conference, 60% said that they were satisfied. So significantly, more of those who actually experienced a conference were satisfied compared to those who went to court. And then you had another one done in Bethlehem, Pennsylvania, done by McCall and Wachtel, again with juveniles. And this is the goal of this program: satisfying victims, repairing harms, re-educating juvenile offenders, offenders owning up to their behavior, lower recidivism rates, providing an alternative to punishment, increasing community satisfaction. Only first-time offenders were eligible. No felony-level crimes were eligible unless specifically agreed by the Chief of Juvenile Probation Board. No drug or alcohol crimes, no sex offenses. Simple assaults were used where there was no serious bodily harm. And summary violation in terms of theft. And the outcome. 79% said they felt that a meeting with the offender had been helpful. 23% said they had a positive attitude towards the offender. 92% said that they would recommend conferences to others. 94% said they would choose a conference if they had to do it over again. And 93% said meeting the offender was helpful. 94% said the tone of the conference was friendly. This other experiment was done with adults, and most of them were in prison. Following up interviews after the conferences, 93% who participated in the London program and 85% in Northumbria thought that the conference went very well. So both offenders and victims normally would participate in such conferences for a number of different reasons. Now, very often, what we find that perhaps persons might believe, well, listen, what really the offender, what would the offender have to do? What is he responsible for? And it takes the line of, for example, if the matter would have gone to court, the magistrate may have placed a fine or even a custodial sentence on the offender. You may not have the custodial sentence in this case, but what you would find that there will be a fine. For example, if someone was robbed of a certain amount of money, he or she will have to pay back that money. And these are some of the forms that it would take. Sometimes a person might only want an apology. The offender is also responsible for compensation and restitution. Sometimes there's an agreement for community service or even rehabilitative programs, because you may find that an offender is really on drugs or so. And in all the discussion, some of these issues are brought up, and there's an agreement which is usually signed and followed up by the facilitator. So some benefits of restorative justice is that it views crime primarily as a violation of law, but as an offense against people and relationship. Not primarily as a violation of law, but as an offense against people and relationships. It seeks to encourage accountability by the offender, reparation, and reintegration and healing. It reduces recidivism. It resolves conflict and eliminates ongoing problems. It provides communities with a satisfying experience. It reduces reliance on the criminal justice system and formal processes. In the process, questions can be asked and answered. Feelings can be expressed in a safe and constructive way. People can express remorse and take moral responsibility for their part in what happened. It can produce powerful emotional responses, leading to mutual satisfaction and socially inclusive outcomes. Conferences, recommendations, and plans, therefore, frequently reflect restorative values, but also at times reflect rehabilitative, retributive, and crime control values. I just want quickly to refer to 10 such experiments which were done over time. And these were done, as we said, in the UK and Australia. Because what happens in these countries, particularly in the various universities out there is constant experimenting, there's constant reviewing of the whole process of restorative justice. So you find a lot of experiments is being done. And so coming out of looking at these 10 different experiments in terms of repeat offending, when you look at the effect size, you will recognize that 9 out of these experiments showed that there was a lessening of repeat offending as against court matters. There's only one And that is the very first one, the Property Australia Youth. If you look at the line straight down with the green line, in this particular one, the first one, you see that the effect size really is statistically high in that repeat offending would have occurred in that group. But for all the others, and this was done follow-up 2 years after they would have gone through RJ. 2 years after they would have gone through this process. This is a follow-up on individuals, and this is the outcome. Now, I'm almost at the end of my presentation. This particular slide I pulled from the annual report of our judiciary. And in looking at it, you can see right here in Trinidad and Tobago, and this was for the period 2013 to 2014, the amount of offenses that went to court. And I know anyone sitting here will, in looking at those figures, would realize that some of these cases will go on for years and years and years. And a lot of these matters involve minor crime and minor offenses. This morning, Professor Narayan Singh mentioned that we need really to be doing some things differently. In the overwhelming precedence of what has occurred with restorative justice conferences, and the fact that these experiments over time have revealed how effective such a process can be in terms of repeat offending. Perhaps the time has come for Trinidad and Tobago to really explore with some of our minor crimes, some of our minor offenses, and get into restorative justice conferences. We can never know how effective it can be. It may or may not work, but if we don't explore with it, we would never really know the outcome. So this is my presentation to you. Thank you very much.